Hey, everybody. Now it's time for your Constitutional Origins flashcards, all in a row. Hope you enjoy. All right, so let's take a look at our first unit's flashcards. This is our longest unit, so there's going to be a lot to look at. Our first topics really rely on our understanding of basic governmental philosophies with regards to limited government. You know, the United States is based on a system that our government should have limits. It's not an authoritarian government. It's not a dictatorship. And at the core of our political system are certain beliefs that come from Enlightenment political thinkers of the 16 and 1700s. First one is natural rights. So natural rights are very simply rights that people are born with, and Enlightenment thinkers articulated. John Locke articulated people are born with rights. John Locke specifically said these rights are life, liberty, and property, and we see the concept of natural rights embodied in the founding documents of the United States. Popular sovereignty is the idea that power comes from the people themselves. It doesn't come from God. There's no divine rulers. But in fact, the people themselves give power to the government. So we have a limited government that's based on natural rights. People have these rights that can't be taken away. And the people themselves have the authority to give power to the government. The idea of republicanism is the idea that people select their representatives to represent them. And that is obviously what our political system is. This is a core idea in American government. In our political government is not Republican in the sense of the political party, the Republicans, but rather the concept of people represent their constituents in some sort of representative body. And then we have the social contract. So the social contract is the idea that people give up some of their natural rights. In the state of nature, they can do anything and they have complete freedom. Some of their freedoms are given up, and in return, the government will provide protection for the core natural rights that they are born with. So you give up your right to harm someone or your right to steal, and in return, the government will protect you from others, and you give up some of your rights in this contract with the government. These concepts are embodied in the American political documents. Okay, the Declaration of Independence, of the rights, the ideals, the core ideals of American democracy that are embedded in the Declaration of Independence. We certainly see the concept of natural rights, the idea that Jefferson really echoes John Locke when he says people have the right to life, liberty, and the pursuit of happiness. You know, he changes property to pursuit of happiness, but really he is embodying this natural rights principle, and that the popular sovereignty is a core, right? We're overthrowing the king. The king doesn't have a legitimate right to rule, and also the idea that there's a social contract that the king is violating these rights. He's not keeping up his end of the bargain. Republicanism isn't really a core ideal of the Declaration of Independence, but rather that comes along in the Constitution. The Constitution embodies the idea of republicanism in this type of government it sets up in a representative body, explicitly in the House of Representatives, and people are elected representatives. So we have these core political principles in American politics and American government, I should say. And the United States government is what we call a liberal democracy, in the sense that it embodies these basic principles of limited government, natural rights, popular sovereignty, a social contract, elected representatives. It's a democratic system, but it's not a pure democracy. And those are underlying key principles of American political thought. So there's our first topic 1.1 on our flashcards. We'll move ahead in the next video. So let's move forward into topic 1.2 for our first unit, types of democracy. So there's different ways of looking at what types of democracies can exist and do exist. And when the Constitution was being debated, there was a real disagreement over what style of democracy the United States, the new country, should have. So at its purest form, democracy would be a participatory democracy. It's one where basically every person has an equal say. You know, you'll see this in like a town meeting, for example, in which everybody is participating equally in voting, and they're voting on actual laws and actual decisions. Now, the larger a democracy gets, the more inefficient and impractical this can become. So then we really down to these two concepts of pluralist democracy and elitist democracy. In a pluralist system, there's really a lot of different voices that are getting access to the decision making. You have a large enough republic in which different interest groups have multiple points of access, different factions have multiple points of access, so people can be represented in different ways, and there's lots of different ideas and viewpoints that are competing against one another. Elitist democracy is kind of in opposition to a pluralist democracy. It's the idea that governing is best left to political elites, to decision makers who know best, who know better than the average, common person or the common citizen. And so some people argue that our system today is elitist because there tend to be wealthier people in office, or perhaps money can buy influence, or higher levels of education get people access to our system. But really, we have a hybrid system. We have elements of a pluralist system, and we do have elements of an elitist system. We have pluralist elements in that everybody can elect their members of the House of Representatives. And of course, everyone in 2020 has the right to vote, with few exceptions, hopefully. But we also have an elitist system. I mean, the president is chosen by an electoral college. We had elitist undertones initially in our system when the Senate was originally selected by state legislatures. Now that has been changed, and they're selected by voters of the state. So you have different aspects of pluralism and elitism. This was a big debate at the time of the founding. And at the Constitutional Convention in the months after the Constitutional Convention, when people were debating whether or not the Constitution should be ratified. In the Federalist Papers, one of our core required documents is Federalist number 10. And James Madison is arguing for the Constitution, saying we should ratify the Constitution. And basically what Madison says is that if we have a large enough republic, then we can limit the influence of factions. Faction being a group of people who are politically aligned, a group of people who want to take control and impose a certain policy. And factions are inevitable, Madison says. We can't get rid of factions. There's always going to be people who have similar viewpoints, who team up, an interest group or political allies. But you have to protect the rights of the minority and make it so that no one faction can become too powerful. And Madison's main argument is if we have a really, really large republic where people vote on their representatives, but there's lots of different representatives from all sorts of different parts of the country under the Constitution, then the impact of factions will be limited, and they won't be able to overrun minority groups and impose their will, because we have so many different groups represented and competing with one another. There's also views on these core concepts of democracy. If you're saying, does Madison believe in pluralism, elitism, or participatory democracy? He really views participatory democracy as impractical, but he does say that our system really has both pluralists and elitists under the Constitution elements. We have a large enough country that there is a wide selection of elites who will be able to best represent the people of the United States. And sometimes when you vote on people, they better represent the people than the people themselves would. But he also has elements of a pluralist philosophy, in which he says we have lots of different viewpoints because we have a large republic and lots of factions. So he really does. You can use Federalist 10 to argue that we have both a pluralist system and an elitist system, and Madison wanted elements of both of those. In opposition, you have Brutus I, another one of our main documents, an anti-federalist paper. And in this document, basically kind of pushes back against some of Madison's viewpoints. And he views the pluralist system as one that could be woefully inefficient in our system, or the government would be too big under the Constitution. And he also says there's a danger of elites taking control and having too much authority, and this could lead to a tyrannical government. So one can assume that the anti-federalists would lean more toward a participatory system. Federalists, of course, being those who supported the Constitution and wanted it to be ratified, and anti-federalists who did not want it to be ratified and did not support the Constitution. And in the ratification debate, anti-federalists were very concerned about individual rights. They felt that the government under the Constitution could have too much power. And what ends up bringing anti-federalists on board in this ratification debate is the promise by Federalists to add a Bill of Rights laying out individual rights that can't be taken away to the Constitution. So they say we'll immediately amend the Constitution, we'll add 10 amendments, and we'll protect individual rights, individual liberties, and also will protect the rights of states, which is primarily what the 10th Amendment does. So that's why the Bill of Rights was added to the Constitution, to bring some of the anti-federalists on board during this ratification debate. We'll take a break up later. So now let's talk about the Articles of Confederation. We've been talking about the underlying principles of our political system. Well, the Constitution was really the second go-around in creating a government. The first was the Articles of Confederation, which was created during the American Revolution, and it was the first governing body of the United States. Now, I'm not going to go over every provision here of the Articles of Confederation, so you might want to take a closer look at this in your notes and in your other materials. But let's talk about some of the key principles, right? So the Articles of Confederation created basically a legislative branch government. It did not create an executive branch, and it didn't create a permanent judicial branch. It just had a legislative branch. All 13 states had the same power. They had basically one vote in Congress. They could send multiple representatives or delegates if they wanted to, but they only had one vote. And so there was a lot of discussion about whether this was fair, because there were certainly states that were larger. You also had a series of key weaknesses and powers that the Articles of Confederation did not have. They really had to request troops from states if they wanted to raise a military. They couldn't directly enforce taxes. They could not regulate commerce between states. So they were fundamentally weak, and this was by design. The people were in the middle of the American Revolution. They were fighting against a tyrannical government. They had real concerns about creating a strong centralized government, and this really wasn't something they wanted to do, and they didn't really feel entirely connected as 13 separate colonies anyway. One of the key events that really highlights the weaknesses of the Articles of Confederation is Shays' Rebellion, which occurs in Massachusetts in the 1780s. And there's basically a uprising in Massachusetts over economic policy, and the Massachusetts government basically requests help from the Confederation Congress to put down the rebellion, and they are unable to get any assistance. The Articles doesn't really provide the ability for a quick raising of armies, and they are unable to assist Massachusetts, which has to raise their own private militia to put down this rebellion. Really leads to some alarm about whether or not the central government is strong enough. Now, if you want to change the Articles of Confederation, in the Articles themselves, they said that you needed a unanimous vote to amend it, which made it virtually impossible to amend, and they needed 9 out of 13 votes to pass any piece of legislation. So it was really this inadequate government. And so the Constitutional Convention is called to try to reform the Articles, but the delegates at the convention in Philadelphia in 1787 immediately say, well, we're going to start from scratch, which is not something they were allowed to do, but they did it. And there are a lot of different proposals and discussions at the convention about what the Constitution should look like and how it should be structured, what powers it should have. But at a core disagreement is over the basic structure of big states versus small states. So the New Jersey plan would have maintained an equal-based representation in a single legislature, a unicameral legislature, and each state would have equal representation. And the Virginia plan would have had a two-body bicameral legislature, and it would have both been based on population, and the larger states having more votes. So the Great Compromise, the Connecticut Compromise, it's all about representation for states. Should it be based on population, or should it be equal per states? The compromise basically sets it up so that it's a bicameral two-house legislature. One is based on the population of the states, and the other is equal per states, the 2 senators. So that's the main compromise that comes out of the discussion about how states should be represented. You also have a discussion about how the president should be selected. So it's really important to understand how the Electoral College works. This takes the selection of an executive, and it basically hands it over to the state legislatures. In essence, it says the state legislatures will award electors, in whatever manner they see fit. And in the modern era, they have elections to do this. And these electors will then cast votes for president and vice president. So you have to have a majority of votes in the Electoral College to win the presidency. If there's not a majority, the vote goes to the House of Representatives. But the Electoral College takes power away from the central government, and it also takes power away from individual voters, and it gives it to state legislatures. So it may not be how we look at the Electoral College today, but it gives it to state legislatures. And southern states were able to go along with this because the number of electors is based upon the number of representatives a state has in Congress, in both the House of Representatives and the Senate. And the 3/5 compromise established that slaves would count as 3/5 of a person when determining the number of representatives a state would have in the House of Representatives. So slave states are able to increase their number of members of the House of Representatives, which is based on population, through the 3/5 compromise, which also increases the number of electors they have, which is why so many of our early presidents came from southern states. So if you ask, why do we have an electoral college, there's a lot of different answers to that question. You know, we don't trust the people. They wanted the state legislatures to have authority. Slavery is also one of those answers because the 3/5 compromise is directly connected to that. There's also a compromise to basically say that the importation of slaves will not be banned for an additional 20 years after the ratification of the Constitution. The amendment process in the Constitution is much easier than in the Articles of Confederation. So there is one primary mode of amending the Constitution that has been used over the course of the 27 amendments. Basically, you need a 2/3 vote in both House and Senate, okay, 2 separate votes in the House of Representatives and the Senate. And then those proposed amendments, that proposes them, they go to the states, and 3/4 of the state legislatures then ratify that amendment. The president has no say in the amendment process whatsoever. The president can't veto it. The president's not involved in it, okay? Now, state legislatures can call a constitutional convention as well, and state legislatures can also have special ratifying conventions. But the primary method is 2/3 of the House and the Senate, and then 3/4 of the state legislatures. That's the one that's been used almost exclusively. So that's a good place to stop here on this video. Some of the core debates and discussions about what the Constitution basic disagreements should look like, and we'll go on in the future and talk about different powers the government has, and this will come up more in our units on Congress and the executive and how they remedy, how they fix the problems of the Articles of Confederation. You know, when we talk about the debate over the ratification of the U.S. Constitution, it's sometimes helpful to connect this to modern-day examples. So if people are concerned about having an overbearing government in 1787, 88, 89, we can connect that to modern-day concerns. You know, there are concerns today about whether or not the government should have the authority to have increased surveillance, and would that be an invasion of someone's privacy rights? That's one of the reasons, if you really think about it, that we have a Bill of Rights, is to make sure there are limits on government actions. Now, surveillance is not exactly in the 1780s the way we think of it today, but those principles of saying let's have limits on the government, they endure. And we still have debates about that today. Similarly, you can ask about questions about whether or not the government should have roles in areas that maybe should be left up to the states. Now, there wasn't really a big debate about federal government's role in modern education, in education in the 1780s, but in the modern realm, there is. Some people think this is purely the realm of the state and local governments, and others say that the federal government should have a role in this now here in 2020. So although the debates over ratification are about issues relevant to the 1780s, we can have those same conversations today about modern political issues, about whether or not the United States government has an overreach when it exercises its powers, or whether or not it's appropriately limited in acting within the guidelines and parameters of the visions of the Founding Fathers. If we take a look at these concepts, I mean, look, these are core underlying principles of the American political system. That's what topic 1.6 is. The separation of powers concept, just quickly stated, is the different powers of the government are split between 3 branches. The executive branch enforces the law. I should start with the legislative branch. They write the law. The executive branch, they enforce the law. The judicial branch interprets the law. Okay, so that's the basic core the core concept there. And of course, under Article 1, you have a list of powers, and Article 2, you have a list of powers. Article 3 is much shorter, but it lists out the cases the court can hear. Checks and balances is related to this concept because it's about how the different branches have different powers, but it is different in the sense that checks and balances is about one branch imposing a limitation on another. Separation of powers is simply the concept that the branches have different powers. Checks and balances is each branch can limit the other. So the executive can limit the legislative, legislative can limit the executive. Legislative can limit the judicial, judicial can limit the executive, so on and so forth. And there are lots of different checks and balances in the system, and I'm not going to go through them all on these flashcards, but you should be familiar with the checks and balances and what different checks and balances there are, and you should know what the Constitution says and in what ways the different branches limit one another. Now, if we go through some of the main provisions of the Constitution, these things will come up again in later units, so you kind of get a double whammy here later in the course. But congressional powers, you really need to know that in Article 1, you have the legislative branch, and in Article 1, Section 8, primarily, you have listed enumerated powers. And you don't need to be able to list all of the enumerated powers, but you certainly need to be able to recognize them and provide examples of some of the key core enumerated powers, such as the power to tax, the power to coin money, the power to raise an army, the power to regulate interstate commerce being one of the most significant we'll talk about in federalism. And then, of course, the all-important necessary and proper clause, which we'll talk about in our unit on federalism as well. Same thing with Article 2. Article 2 creates the executive branch. You need to know which article creates which branch. And you again need to be able to list significant powers, which we'll do again in our unit on the executive. The president is the commander-in-chief of the army. The president appoints ambassadors and government officials. The president can pardon people. The president vetoes legislation. The president appoints Supreme Court justices, which is incredibly important. President signs treaties. One of the checks, of course, is that the Senate ratifies those treaties. We'll talk about Article 3 more in the judicial branch, so I'll just quickly say, make sure you know Article 3 is the judicial branch, and in our unit on the judicial branch, we talk about what Article 3 actually says and how it sets up the jurisdiction of the courts. And then, of course, you need to know multiple examples of checks and balances. And you can look these up in our notes. I'm not going to go through all of these but legislative, you probably should make a list of all the different types of checks and balances that there are. How does the legislative check the executive and the judicial? How does the executive check the legislative and the judicial? How does the judicial check the legislative and the executive? So if you have all of those different lists, then you'll have a core understanding of how checks and balances work. So how is impeachment a check and balance? How is judicial review a check and balance? How is veto a check and balance? How is the power of the funding of Congress over executive actions? How is that a check and a balance? And this core concept of checks and balances emerges in Federalist 51, another Federalist paper. And in this one, Madison basically lays out the idea that we have separated powers. This is a good thing that prevents tyranny. And he also says that we have checks and balances, and he uses core concepts of checks and balances as examples of how we will not have a tyrannical government. And importantly, he says famously, ambition must be made to counteract ambition. Men are not angels. If men were angels, we wouldn't need a government. But we do need a government, and that government still needs to reflect human nature. It needs to be limited in and of itself. And so we need to counteract the ambition of one part of government with another. We certainly see examples of checks and balances in the modern era. And you can see examples of this in some actions right now. If people feel that government officials are abusing their power, there are impeachment provisions. Impeachment is in the Constitution. It's in Article 1. It talks about how basically the Congress in the House of Representatives needs a majority vote to bring charges, in this case to a president if we're talking about what's happening in 2020, and then that vote goes over to the Senate. There's a trial in the Senate, and then you need to have a three-fourths vote to convict. I said three-fourths multiple times, but it's 2/3 majority vote to convict the president or any other public official. So Supreme Court justices can be impeached. There's also investigations. Congress can investigate. So, there are limitations. If ambition is going to be made to counteract ambition, there are provisions in the Constitution to help government officials do that. So here's a good place to stop. So let's do a rapid fire review of some key constitutional provisions which are covered in our first unit. We should also note that a lot of these things come up again in later units, so you really are covering these concepts from multiple angles. So first, let's understand Article 1 is the legislative branch. Let's recognize that it is a bicameral legislature with a House and a Senate. What are the different requirements between the House and the Senate? So in the House of Representatives, you need to be 25 years old. In the Senate, you need to be 30 years old. So the House of Representatives originally was chosen and still is chosen by the voters in districts, and the Senate was chosen by state legislatures. So those are key distinct differences between the two. Senate has 6-year terms, House has 2-year terms. So they're designed to be different. You know, the House is supposed to be closer to the people, closer to the voters, and the Senate is supposed to be a more mature, continuous body, and they have those different structures and requirements for those purposes. Continuing with our legislative branch discussion, the House and Senate have different powers. This is going to be covered in more detail in our Congress unit, but quickly, some of the important powers that are unique to the House. It's worth noting that the House is where all revenue bills originate. It's also worth noting that impeachment begins in the House. In the Senate, you have a lot of specific powers that are specific to the Senate. They have trials for the impeachment. Other specific powers to the Senate are they ratify treaties, they confirm presidential appointments. So they have significant powers that the House does not have. This is really an interbranch check. So there's the powers of the legislative branch are further split in between the House and the Senate. In regards to the vice president, they have very few constitutional roles. A vice president is simply someone who becomes president if the president dies, or they cast tie-breaking votes in the Senate as president of the Senate. If there's not a tie in the Senate, then they don't pass. They don't have any votes at all. So really, they have very few constitutional roles. Moving on to Article 2, basic provisions and concepts regarding Article 2. Again, this will be covered in our unit on the executive as well. Understand that the president has both formal and informal powers. Formal powers being powers that are explicitly designated in the Constitution. Informal powers being powers that are derived indirectly from the Constitution or have simply grown over time. So formal powers would be the veto or the pocket veto, the power to sign treaties, the commander-in-chief of the military, pardoning of criminals, appointing of Supreme Court justices. Informal powers are going to be things like executive agreements, the bully pulpit. Executive orders, you could say, are informal in that they're not derived or at least expressly enumerated in the Constitution. Now, with regards to the Electoral College, why do we have an Electoral College? There's different reasons. We talked about this in our executive unit as well. The Electoral College is designed to make sure that the state governments have a key role in choosing the chief executive. They also make sure that slave states, originally under the Constitution, states with slaves, that was counted towards 3/5 of their population. And the Electoral College number of electors per state was based on the membership in the House and the Senate. So if states had a lot of slaves, they got additional members in the House, which means they got additional electoral votes. Also, you could argue it's a matter of having a safety valve and not trusting the democratic system in its purest form. So the Electoral College was not a truly democratic system. There was really an indirect vote for president. The voters were not choosing the president, but rather the electors were. Moving on to Article 3, these things are covered in our unit on the judiciary. So the Article 3 of the Constitution sets up that there will be a Supreme Court. It sets up what the court's original jurisdiction would be, what cases will they hear. And it says that the legislative branch will actually create a court system, determine what the court's appellate jurisdiction will be. It does point out that justices will be chosen by the president, confirmed by the Senate, and they will serve for life in times of good behavior. So they're supposed to be an apolitical, unelected position, not subject to the whims of politics. Article 4, full faith and credit clause. The fourth article of the Constitution is put in there to ensure that there's some consistency between states and that decisions that are made by one state, they're still valid when people go to another state. So contracts, for example, are valid across state lines. So this has been used as kind of a binding the country together, so to speak, provision of the Constitution. The amendment process, very, very important concept here in Article 5. The formal process of amending the Constitution, you got to know this for your midterm and for your AP exam. Separately, the two-thirds of both the House of Representatives and the Senate vote to propose a constitutional amendment, and then 3/4 of the state legislatures vote to ratify that constitutional amendment. That's the main formal process. There is another process that is not used, except for one minor exception, in which a constitutional convention can be called by 2/3 of the states, and then states separately could have ratifying conventions. 3/4 of the states would have to ratify this amendment in ratifying conventions. That is another way of doing it. But the primary method is the one you really need to be responsible for. 2/3 of both the House and the Senate and 3/4 of the states. This is the formal process designed to bring a lot of different stakeholders involved in the process, make it difficult. The president is not involved. So that's formally how it's done. Now, informally, it's important to note that the Constitution can evolve through judicial interpretation, through social change. So the Constitution, the 14th Amendment, for example, what it means to be denied equal protection of the law, as time goes on, the Supreme Court interprets this as meaning people and groups that weren't necessarily what was on the mind of the people who wrote the 14th Amendment in the 1860s. So the 14th Amendment wasn't meant to apply to women or members of the LGBTQ community. And now the Supreme Court has interpreted multiple times that it does. So the court can evolve its interpretation of the Constitution, and so the meaning of the Constitution can change without constitutional amendments. Article 6 is the Supremacy Clause. It's important to note that this is a provision which expands the power of the federal government at the expense of the states. It says the federal Constitution is the supreme law of the land, and we talked about this in particular when we talked about the case McCulloch versus Maryland. Ratification, it's important to note Article 7 simply states that 9 out of the 13 original states needed to ratify the Constitution for it to go into effect. So there's a rapid fire review of some main provisions of the Constitution, and each of these provisions, or many of them I should say, are covered in more depth in some of our other units later on.